Hello, it's me, Joey, and today I decided to do something new. I'm calling it This Week I Learned because it's talking about what I learned this week, and I'm going to try to share it with you all. So, this week I learned about United States constitutional law. What I did for this was I'm very partial. I really love when like online free classes that colleges will put up. Like I don't know if you've ever used MIT OpenCourseWare, but what a lot of colleges will do nowadays is they'll put some of their lectures online for free, and that's what I did for this. And I also read a bunch of Supreme Court cases, which was not the most interesting use of my time, but oh well. There's a lot here. Let me see if I can show you this. So these are all the ones I had to read. Yeah, so a fair number, I would say. So without further ado, I think we should get into the part where I summarize everything for you. So, a very important part of constitutional law, of course, is the origin of the Constitution, because it provides us the base on which we lay everything else, right? So, as you probably know, in 1776, the 13 colonies declared independence from Britain in the Declaration of Independence, and then we had the Revolutionary War, and after the Revolutionary War, the colonists needed to establish their own government. And from experience with England, they knew that they didn't want their national government to be too strong that it would restrict the rights of citizens. So they created a document called the Articles of Confederation, which was their first government, and it had a very minimal federal government and a lot of power to the individual states. But the problem was that it wasn't working because the states weren't agreeing with each other. So states would make trade would like negatively influence the trade of other states. They'd sometimes even fight over trade. And in general, there was not much that was getting done. So the Constitutional Congress was called. Originally, it was just supposed to revise the Articles of Confederation. But eventually, they decided to create their own document, the Constitution, and said that it would be ratified by 3/4 of the states. And as we all know, it eventually was. But it was not that easy, because when the Constitution was written, there was a lot of different voices in the United States that had very different contrasting opinions. So, for example, when it came to deciding the Congress, or the Senate and the House of Representatives and such, originally it was just going to be, one legislative body, but there was conflict. Would that body be based on state populations, or would it be an equal number of representatives for each state? And eventually, the framers, as they're known, the people who wrote the Constitution, decided on a bicameral Congress with one group consisting of representatives based on states' population, and the other having representatives equally distributed among the states. And another big issue was that of northern states versus southern states with regard to slavery. So, for example, in the Constitution, slavery is not really talked about that much. They like to sort of skirt around it, but there are clauses that deal with slavery indirectly, like the 3/5 compromise, which would say that anybody who's a slave counts as 3/5 of a person when voting for representatives and such, or not when voting, when determining how many representatives you're going to get, which, doesn't seem the greatest, but that's what they decided. And what the Constitution did was it established 3 branches of government that were supposed to balance each other and keep each other from getting too powerful. So the legislative branch, as we talked about earlier, is Senate and the House of Representatives. They make laws. The executive branch, which is the president, his cabinet, and all his executive officers, enforce laws. And the judicial branch, which is the Supreme Court, ran the law, or like the court system of the United States. But obviously in the very early days of the Constitution, a lot of these things changed very, very rapidly because the framers could not have anticipated everything that happened. One of the biggest things was the advent of political parties, which meant that, now the president and Congress could all be on the same side, and then they wouldn't be balancing each other at all. But an important early development that's significant in constitutional law is the advent of judicial review, which says that the Supreme Court can declare whether or not a law is constitutional. So the important case that decided that was Marbury versus Madison. Second president of the United States, John Adams, was acting as president when Congress first established the lower federal courts. So he had the opportunity to appoint justices to the lower federal courts. He had to get them approved by the Congress, and by the time they got back and he was able to stamp and deliver them, it was only a couple days left until the next president, Jefferson, took office. And so one man, Mr. Marbury, didn't get his official documents until after Jefferson was already president. So the case came to the Supreme Court, and it was very important because the court said, now I think it probably, if this case came about now, it would have been decided that Marbury was in the right and Madison was in the wrong. But the justices here had another motivation in deciding this case. They ruled in favor of Madison so that the other branches of government wouldn't try to overrule the decision. But they also said that it was unconstitutional, which up to that point had not been something that had been done by the Supreme Court. And that's what established the system of judicial review. So that's a pretty important part of the Supreme Court nowadays. But there are still limits on what sort of things the Supreme Court can do. And most of this requires what cases they can actually hear. So, for example, the Supreme Court requires that all cases that come before it have what's called standing, which means they can be a case that the Supreme Court can decide. And one important part of standing is that there must be a requirement of injury. So a case I'm going to talk about here is Sierra Club versus Morton. And the Sierra Club, as you might know, is an environmentalist group. And they were plaintiff, and Morton was the defendant. And what the Sierra Club was protesting was the development of skiing in the Mineral King Valley of Sequoia National Park. And the Supreme Court eventually said that they would not hear the case because since Sierra Club members had not personally been affected by this development in Sequoia National Park, they lacked standing to bring a case before the Supreme Court. So it went back down to the federal courts, and it might have gotten back to the Supreme Court, and I'm not sure what happened, what would have happened then. But another important part of standing is that there's a causation requirement. So it must, in order to have standing, there must be a clear harm and not like a general harm. So the key case here is Allen versus Wright. So Allen versus Wright was about the IRS in which I don't remember the plaintiff or the defendant. I'm pretty sure it was the plaintiff because I imagine the IRS was the defendant. And that they said that the IRS had been like supporting schools that were practicing discrimination, and not that he'd been getting tax exemptions, even though the IRS said that, if you're a discriminatory school, you couldn't get tax exemptions. And the Supreme Court said that that didn't have standing because there was not a clear harm to them. It was a generalized issue. They couldn't give a specific case. And one of the last important requirements of standing is that it be redressable. Basically, you cannot bring a case before the Supreme Court if the Supreme Court believes that there is no way that the harm can be you could receive redress for it. Because the Supreme Court cannot do too much. They have limited powers because they're just a court. Unlike the executive branch, which is in control of the army, they don't really have any way to enforce what they say, and they can't force particular demands. And something that I don't think is part of standing, but has generally been not heard by the Supreme Court, is cases that are of a political nature. So if a case is very political, the Supreme Court won't review it, especially if the remedy is political. Like, if winning this case is going to give you some political benefit, the Supreme Court probably will not hear the case. Some examples of these that I'm not going to get into the details are Goldwater v. Carter, Lulak v. Perry, and Nixon v. United States. And then that's all I'm really going to say about the judicial branch. But the Constitution also establishes two other branches of government that are in charge of balancing each other, balancing the court, and making sure that the Constitution is upheld in the land and that we are a functioning country. And the next branch I'm going to talk about is the legislative branch. So, as a general rule of thumb, Congress is allowed to do things that are explicitly stated in the Constitution. But if something's not in the Constitution, they need to interpret it out of something that is, otherwise they're not going to be allowed to do that. And one clause that's particularly important for federal legislative policy is the Commerce Clause of the Constitution, which says that Congress has the power to legislate commerce between the states, or between countries, or with the Native American tribes. Yeah. And that's often interpreted a fair number of different ways. So, I've got some cases here about the Commerce Clause. Let me just find one that I think is good for this. Okay. So a lot of times, in interpreting things like the Commerce Clause, there will be periods of time where the court will have different opinions, because obviously the justices have different opinions about what the meaning of the Constitution is. So there have been some times throughout American history where the court has said that in order to apply under the Commerce Clause, it just has to in some way involve business between the states. So, for example, there was, what's a good one? Do I want to do Heart of Atlanta Motel? Let me see if I want to do Heart. Yeah, I'm going to do Katzenbach versus McClung instead of the other case I was just talking about, because I'm going to bring that up later probably. And in Katzenbach versus McClung, the court ruled that discrimination in restaurants was not only for restaurants that serve people that come from other states, but also use food that comes from other states. And the court said that because this is related to interstate commerce in some way, that it is under the Commerce Clause. The other perspective says that the federal government can only use the Commerce Clause if it is a significant contribution that directly to interstate commerce, and sometimes commerce is even defined as only the buying and selling. So there have been cases where it's not even the production, or not even like things like production. So the important case here is Lochner versus New York, which is primarily about due process and such, but the main thing here was that Congress could not regulate the hours of time that a baker can work. You can't say a baker can only work this many hours. And this had a lot to do with not just the strictness on the Commerce Clause, but just a strictness in general about Congress's ability to do things. So it's also primarily a 14th Amendment case, which we'll get to later. What's another important part of federal power that I missed? I have some notes here that I'm reading that I've taken to help me remember everything. Okay, and a lot of times Congress likes to use the Commerce Clause even when there is another clause that would probably work better. So the most important thing here I would say is when talking about Obamacare, because there was what was called the individual mandate, which said that, you had to have health insurance. And originally, Congress tried to do this under the Commerce Clause, but eventually it was determined that a different clause, the taxing clause, would be more constitutional. Otherwise, it probably would have been struck down under the Commerce Clause, because currently the court is very much against, they're back in that perspective of you need to have a high standard for the federal government. And then an important part of federal power is when federal power and state power is in conflict, because in the federal power is the law of the land. It overrules state law in a lot of cases, but there makes a lot of interesting situations where a federal unconstitutional law is being applied to overturn a constitutional state law, which is obviously grounds for a Supreme Court case. And lastly, I think we're going to talk about the executive branch. So the important part of the executive branch is that they have a rather interesting set of powers. So the president can, he executes, he's the executive branch, so he executes the laws, but he's also commander-in-chief of the armed forces. He's in charge of writing up treaties, although Congress still approves them. He creates federal administrative agencies with Congress's approval. He appoints Supreme Court justices with Congress's approval. But as we talked about with the party system, there are times when it's not hard to get Congress's approval, even when Congress probably would, if it was different. When Congress is the same party as the president, it can be too easy for the president to get approval. And when there are different parties, it can be too difficult for the president to get approval. And you need to find, a balancing ground there. So, Article 2, as the part of the Constitution that deals with the executive branch, and it is actually quite not very long. It's a rather short part of the Constitution compared to some of the other articles of the Constitution. And it lays out all these powers that I just described. And it also says things like, the president can be impeached, and things like that. And there's a couple of very important cases involving executive power. The main one among these being Korematsu versus United States, which is about the Japanese internment during World War II. And the Supreme Court sort of ruled with the president, sort of against. The president, or the executive branch, won in this case. It was said that they had every right to say to Japanese Americans that you cannot be in particular areas in California and such. However, they also said that the internment itself, no. I think that's, to us nowadays, that would be quite clear. But just something to keep in mind when it comes to judicial stance on the executive branch. And lastly, I want to talk about the relationship between the federal government and the states, sometimes called federalism. And as I said earlier, a lot of times federal law will supersede state law when they're in conflict. So one example of a case that was kind of important a little while ago was Arizona versus United States. Arizona passed a law called SB 1070, which made it was an immigration law that said that officers can detain people who are to verify their immigration status. And the Supreme Court sided with the federal government under the idea that immigration is a power of the federal government, and thus it overrules the state law in this case. And another area is where the Commerce Clause, even when it's not being actively applied by Congress, can be used in a dormant capacity for when it comes to state laws. So, for example, I'm in Illinois, so I'm going to talk about Illinois, which is, I believe the case here is Bibb versus Navajo Freight Line. Bibb versus Navajo Freight Line, which says that trucks had to have curved mudguards. And it was said that this law created an undue burden on interstate commerce and thus was an unconstitutional law. In general, if a law specifically makes it harder for other states to do business in the state, it's going to get shot down for under the Dormant Commerce Clause, unless it meets what's called strict scrutiny, which says that it's necessary for a very important state purpose. So, for example, Maine versus Taylor, which was upheld. Maine made a law that prohibited out-of-state bait fish, and the law was upheld because it was determined that making them allow bait fish in would be incredibly detrimental to the Maine ecosystem. And so thus it was a necessary step for an important government purpose in Maine. And lastly, I just want to talk about, well, not lastly, but lastly about states. I want to talk about the 14th Amendment, which more generally, is about making sure all citizens have their immunities, their rights and their privileges. This includes African Americans, because this was a Reconstruction law. But also, one of the most important things it does is it says that the Bill of Rights and the amendments that apply to the federal government in general apply also to the states. When these rights come up in a Supreme Court case, they can be what's called incorporated, which basically means the court says, yeah, these also apply to the states under the 14th Amendment. So that's going to be important because the last thing I want to talk about is about your personal rights. So let me just switch over to my notes because I wrote these on a separate section. Okay, so some rights that have been important in Supreme Court cases are mainly two, actually. These are the right to well, there's a lot of rights that are important. I'll talk about two big ones right now. starting with right to privacy. It's not said in the Constitution that you have a right to privacy. However, in a great many Supreme Court cases, it has been said that this is an important right for every American citizen. And so this has come up a lot in more recent cases. So, for example, the right to privacy has come up in cases about interracial marriage, about abortion, and about gay marriage, and other similar things. And the right to privacy generally includes a few things. It includes rights to marry. It includes the right to have children, the right to choose not to have children. It includes things like the right to, not the right to, but more generally the impetus to keep families together, like more of a visitation type thing, and also to the parental right to choose how your child is raised. Those are all really under the right to privacy. So there's been so many cases about these. Ones you should probably know are cases like there's so many cases here, and I have to pick the important ones. Buck versus Bell, that says that eugenics is well, they actually declared a eugenics law constitutional, but eventually this was overturned. So it's important for, talking about how the right to privacy wasn't always such an important thing in the court's eye. Skinner versus Oklahoma, I believe, was the case that overturned it. An important case about visitation is Stanley versus Illinois, which says that, the father has a fundamental right to see the children. And also cases like Mayer versus Nebraska, which says that, well, it more generally says that parents have the right to choose how their child is educated, but more specifically in terms of the language in which they are educated, because there was a state law that said that you couldn't have German spoken in schools, and the court ruled this unconstitutional. Another one is Troxel versus Granville, which says that a mother can limit grandparent visitation. So, if the parents of a child don't want them to meet particular extended family relatives, they can choose not to do that. Griswold versus Connecticut says that you can buy and use contraceptives. And then the one that you've probably heard of before is Roe v. Wade, which the court ruled that abortion is a fundamental right. But this was not the end of things. That came up again in Planned Parenthood versus Casey, in which the court found that abortions can be regulated as long as it doesn't place an undue burden on the right to abortion. And there's a whole bunch of Supreme Court cases dealing with the specifics of what laws can be made regarding abortion. And then another important right is the right to vote, which is protected by several amendments, which makes it, I would say pretty clear that it's important and that every American should have the right to vote. But one of the last things that I'm going to talk about, in fact, it might be the last thing, because I'm not going to talk about First Amendment rights, because I was going to take a class about that, but I didn't get to that. And then also, so everything I do know about that is probably common knowledge. If you want more information about First Amendment, I guess I'll make another video about that later. But the last right we're going to talk about is the right to equal protection under the law, which more generally, every United States individual, a citizen or legal immigrant, has the same rights and privileges under the law. You can't be discriminated against. So there's a lot of cases dealing with two big forms of discrimination, but there's also other kinds of discrimination. So the big one, of course, the big two, of course, are racial discrimination and discrimination based on sex. So I'm going to, once again, lots of cases here. I'm just going to talk about a few. So it started with the Dred Scott decision, which you've probably heard of, which ruled that a slave is not a citizen and cannot sue in court. But eventually we had the Civil War, and afterwards we had a period known as Reconstruction, in which a lot of amendments were passed to give African Americans rights. But for a long time, these rights were still denied under what are called Jim Crow laws, which were laws in the South that discriminated against African Americans. And so then eventually, these Jim Crow laws were at first upheld in Plessy versus Ferguson, but it sort of gives you an idea of how the court can change its mind over time as the justices come in and out, which is that almost 100 years later, in Brown versus Board of Education of Topeka, Kansas, the same Jim Crow law, segregated public schools, which is an important part of Jim Crow, was ruled unconstitutional because it's inherently unequal. Plessy v. Ferguson said that you can have separate facilities as long as they're equal. Brown versus Board said that separate educational facilities are inherently unequal. Another important case we just talked about was Loving versus Virginia, which said that, interracial marriage is, you cannot, to deny interracial marriage is unconstitutional. Another similar case is Palmore versus Sidoti, which said that in an interracial marriage, the race cannot be used to determine custody of the child, nor can, a parent entering an interracial marriage be used as an argument in custody agreements. So, for example, if a couple had a child, then divorced, and one of the parents married a person of a different race, that could not be used as grounds to deny custody of the child. And as I talked about strict scrutiny earlier, there's what are called face-neutral laws, which are laws that, as written, do not discriminate against African Americans or any race, but which, in their application, do. And the Supreme Court has said that in order to be unconstitutional, you have to show that there is a discriminatory impact, and you have to show that there was a discriminatory intent when the law was written. And so this strict scrutiny means that there's not a lot of laws that have been ruled unconstitutional that are face neutral. So you have a very high bar that you have to meet. And then the other kind of discrimination that's important is, there's lots of kinds, but the other big kind I'm going to talk about is discrimination based on sex. There's a lot of cases. Those of you watching who were in my U.S. history class last year probably remember that we talked about a bunch of them. But the difference in sexual discrimination is that, unlike race, there's actual biological differences between a man and a woman. And so for these laws that give different treatment to the two men versus women, the court actually created a new level of scrutiny. They said, we don't want it to be low, I forget what it's called, but the low level of scrutiny. And we don't want it to be strict scrutiny, because we want to make room for these biological differences. So they created a new kind of scrutiny called intermediate scrutiny. So there are laws that treat men and women differently, that have been upheld as constitutional under intermediate scrutiny. And then not lastly, but the two other kinds of discrimination I want to talk about is one that, discrimination based on sexual orientation. So discriminating against people based on their sexuality, which is something that has, let me check if it's strict scrutiny or intermediate scrutiny, but it might not even, oh yeah, no. So the court has, in general, ruled it constitutional, but they tend not to give a level of scrutiny when it comes to these cases. So it's really hard to tell what level of scrutiny would actually need to be met to make a law which treats people of different sexual orientations differently from each other. And the important cases here are United States versus Windsor, which ruled that marriage includes same-sex partners, and Obergefell versus Hodges, which ruled that laws in particular states which defined union as between a man and a woman were unconstitutional under the 14th Amendment, as we talked about earlier, that the federal applies to the state. And I think this has gone on a very long, or not this particularly, this video is going on for a very long time. So I'm just going to briefly touch on the last one, which is one that'll probably be more important in the future, which is discrimination based on citizenship. And when I say that, I do not mean discrimination against illegal immigrants, but rather discrimination against legal immigrants who are here on a visa or such. Because there's plenty of laws which say things like you have to pay for public education if you're not a citizen, or that deny equal protection of the laws to people who are immigrants and not citizens. And so it'll be interesting to see in the future how these laws are brought up in the Supreme Court. And I think that is going to conclude my video. If you have any questions, leave them in the comments below, or ask me in person. And if you like this, I'll do another one. If you have a particular topic, let me know that you want me to do. I might do these every month instead of every week, because this week I learned it seems like it's going to be intense, and I would rather do it once a month instead. Plus, then I can fit more in it. So, have a good day. Goodbye.